Okay, the meeting started. It's actually recording. We're gonna run over here and all right, go to intermission.
sign-in sheet?
Yeah, I'm waiting more people arriving.
Okay.
We made a copy now. Okay. Mark,
Thank you.
I are ready to go with the intermission, so it's supposed to be on that.
Hey, Jessica.
You only need to swipe, okay?
Okay.
Yeah, the mic's
On.
sensitive.
Okay.
It's so it's on right.
That is a copy, and this is because it's an attorney.
Okay.
Okay.
Thank you.
You're welcome. Thank you. It's recording up, right?
Yeah, we're just waiting for Nasli. Madam Magistrate. Ooh, I didn't expect all that. We're ready when you're ready.
Good morning. We'll now call these proceedings to order. Today is April 19th, and the time is approximately 9:07. Before we begin, I will read a opening statement so that you have an understanding of how these proceedings are conducted. Ladies and gentlemen, welcome and thank you for being here today. Please turn off any cellular phones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that may come before the special master, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by a special master. That will be myself today. My name is Andre McKinney. The purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special master assigned to hear today's cases. My responsibility is to act much like a judge in court, and that is to hear cases presented by the code enforcement officer and to hear contradictory arguments presented by the alleged violators. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer. These hearings will not be conducted in accordance with the formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or the code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witnesses, regardless of which party first called him or her to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special master are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties, to issue orders having the force of law to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial, competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, the administrative cost of the hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of the special master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special master. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of the civil violation charge, you will be assessed an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments have been heard. May we have a roll call, please?
Chief Code Officer Joseline Ramirez for the Town of Pembroke Park.
Assistant Interim City Attorney Brian Sherman.
Does the town have adoption of minutes?
Yes. We have minutes for the month of October 2022, month of December 2022, and February 2023.
Any discussions or changes on said minutes?
No.
The adoption of the minutes shall be entered in the record as presented. Are there any deferrals, additions, or modifications to today's agenda?
Yes. We had a few last minute requests, and we're going to add for an abatement case 5070, case 6051. We had two cases that requested an extension of time. That's case 5672 and case 6185.
Are those all the additions?
Yes.
All those who will be providing testimony in today's hearing, if you could please stand up and raise your right hand for swearing in. Do you swear and affirm that the testimony you will present today will be the truth? Yes. If so, say I do. I do. Thank you. You may be seated. The sign-in sheet reflects that we do have a single attorney on a case, and that is case number 8359, Murray Family Associates. Good morning. If you could approach the lectern, and I will hand it over to the code enforcement officer to present this case.
Thank you.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8359, property owner Murray Family Associates LLP, site address 3192 West Hollandale Beach Boulevard, unit GHI&J, Pembroke Park, Florida. A notice violation and a copy of the notice of formal hearing was sent by certified mail March 31st, 23rd, posted to the property on April 7, 23rd. The violations are for operating without a business tax receipt. Each unit location requires a business tax receipt certificate of use. Business was expanded and commenced before the issuance of a BTR CU in unit GHI. Obtain BTR CU at Town Hall. Item number 2, installed about 18 plus video booth with electrical without a permit. Obtain plans for permit and complete all inspections. Item number 3, installed electrical cameras without a permit. Item number 4, installed electrical outlets without a permit. Item number 5, installed magnetic or security locks without a permit. And for all those items, they have to obtain plans and complete all inspections for the permit. And I also would like to state that this is a repeat violation of the plaza, referencing case 7225, which also had no BTR and no permits for a tenant build-out. My recommendation is to give them 30 days, if not a $500 per diem and a $100 admin fee.
Good
I'll
morning.
introduce myself, Special Master. My name is Luke Leroux. I actually represent the tenant, which is Expressions Adult Boutique. I spoke with Rebecca O'Meara, who represents the owner. We only found out about this last week, and I will explain some of the obstacles that my clients have. The gentleman that was the human being that ran the entity that runs this business passed away last year. His wife lives in Kentucky, and she was not the primary person responsible to watch the business. So a lot of this has come as a surprise to us. So I immediately, upon getting sent these materials, evaluated them. I did speak with Ms. Ramirez and sent my notice to find out what I had to do to make sure that I was here in an official capacity. And I ended up discovering that there's a significant amount of work to be done. I got a hold of the people at Streamline Electric. They went and did an inspection. And according to them, to do this properly, they need to get architectural plans and actually have a general contractor pull the permit. Most of this is electrical, and I asked him what kind of a time frame he needed with that. He said that he would need at least 3 months because he doesn't have any control over the architectural plans or the general contractor. So there's a number of players that would be involved in order to bring this into compliance. But I would like to just state for the record that the intent is to absolutely address all of these concerns and make sure that everything is taken care of properly. And I would imagine I have to speak with Mr. Sherman about the licensing issues. I'm not really sure where those stand, but quite honestly, if this was an oversight because of Mr. Philpott's passing, I apologize. And I was curious if the prior violation, I know this is a strip center, would that have been a different unit, or was it the same units, or I'm not really sure. I was unaware of any prior violation. So in any event, I would just like to ask for the extra time to get this done properly, and I will definitely speak with Mr. Sherman about all the licensing issues, and we'll get those resolved as quickly as possible.
The town's position?
Ms. McKinney, may I?
Yes.
It's as far as the original units, which I believe are I and J. Is that correct, Mr. Ramirez? Those are the original units that were there. That was permitted and when they originally moved there. It's my understanding, and please confirm, that it's the expansion into what is it, into G and H. That expansion was not approved. So even if you correct all the interior issues, then it's the zoning that's going to be the issue, because again, that was originally there, that was allowed, that was permitted.
Right.
But the zoning changed, or it was existing non-conforming. Either way, it was, those two were originally permitted and it's fine, but that use is no longer even allowed in that strip center. So even if you go ahead and make all those corrections, the zoning isn't going to change. So it's the use in that expansion becomes the big issue. Is that correct, Ms. Ramirez?
Correct. Because if I may add, so we have a BTR application from August 2009, as he mentioned. It's for Unit J, and it was for adult books / videos retail sales. So more activities happening, illegal activities happening that was never approved. So, and they expanded and made booths, video booths. So none of this was approved. So that, like he mentioned, it would be the first, to get this approved, which we don't, based on our codes, it won't get approved because it's not in the right zone. And more specifics. So that would be the first step. Now, if it's not approved, then it would be to demo everything that's inside.
So as I understand it, the business, and I'm not really familiar with this because when I work with this client, I did it at similar businesses up in Tampa. I've never had the pleasure of coming down here on this before. So originally they got some kind of existing non-conforming use status for I and J, and then spontaneously expanded into G and H without any approval.
There you go.
Sounds like a big issue.
Right. There are some questions as to the original approval, but they were there. They got approved. They've been there for a long time for the original approval.
Right.
That being said, that is not an issue. But it's that expansion, and then of course adding the booze and adding the other things that they've done there. So even if you correct all the electrical work, it's not going to change the zoning.
Understood.
That's going to be step one.
Right. Well, before we start hiring architects and things like that, would I be capable of communicating with you just to get all of the different code sections and make sure that I can research this properly? If it's not in that no matter what repairs there are to the electric, it's not going to make a bit of difference.
It's not. Of course, there are other, arguments or variances you might be able to get. The likelihood of that would be up to between you and your client. If that's an avenue you wish to pursue, I don't know the outcome of that one way or another.
Right.
But yes, happy to have that conversation with you. But from our initial review and from speaking with Ms. Ramirez, that's a hurdle that, again, is very difficult to overcome.
All right. I know that any kind of zoning procedures do take some time. I don't know if there would be any waivers or variances even available for this until we have a conversation.
Yeah.
Do you think I could still request the 3 months to try to resolve this? I mean, I'll certainly do everything I can to get it done as swiftly as possible, but it seems that there is a lot of preliminary research that has to be done before we even figure out where this improper electrical work came from.
Officer Ramirez, your position on the request?
Because this plaza has had repeat violations where businesses go inside and they just start, doing illegal operations. It's a repeat violation. I believe 30 days is sufficient to figure out the zoning issues and whether they're going to remove everything. Now, if they need an extension after that, but I think that this needs to move along rather quickly.
I understand the officer's position very well. I would hate my clients to be held accountable if the owners of the plaza have not been responsible previously. I'm dealing with folks that at this point are just very unsophisticated in these matters, and I'm going to need to do the research. You could, perhaps if we could compromise at 60 days, if that meets with your pleasure, that would be much appreciated.
Okay. Any other from either side? Okay. Based on the testimony and evidence presented, I find there is substantial and competent evidence to support the city's position. The respondent is ordered to come into compliance within 60 days, or face a per diem fine. And Officer Ramirez, that was, according to my notes, was that $100?
The admin fee is $100, the per diem fine $500.
Okay, I'm sorry. Yes, it is a repeat violation for the record. Come into compliance within 60 days or face a per diem daily fine of $500 per day. You are assessed $100 administrative fees. And please keep in contact with the officer with
she's-
regards to how far along you get. I would imagine at some point the decision as to which path is going to be, viable for compliance.
She's been very wonderful to me so far, so we'll keep in communication, and I deeply appreciate the privilege. All right. And I'm going to come up and get your phone number, if I may.
Sure. Nice to meet you. No pleasure, absolutely. Pleasure.
Please hold on a second. Sir, please hold on a second. I will give you a copy of your order, okay?
I'll just sit over here till I get it.
Yes.
Thank you very much.
You're welcome.
Next case, when you're ready, Officer Ramirez.
Next case is on section 9.2 of the agenda, case 5549. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 5549, property owner VNA Miami LLC, site address 4400 West Hallandale Beach Boulevard, Unit 6, Pembroke Park, Florida. Notice of hearing to abate was requested on April 17, 23rd and April 18, 23rd. The fine amount to be abated was requested to abate is $69,750. It is town's motion to abate this fine by 85%. And that amount is $10,463. That does not include the admin fee, as the admin fee has been paid already.
Good morning. If you could state your name for the record and your position.
Claudine Thorpe.
Can you speak up closer to the mic, please? Thank you.
Claudine Thorpe
Okay.
from Anoints of Body of Christ in Hallandale, Unit 6. I'm here today to thank you guys from the last time I was here and to ask for the fees to be mitigated that lower for me, because I'm not able to pay for the amount that is accrued. I have paid for contractors and demolition and everything that they've asked me for. I'm sorry for the time that went over, because I had to do asbestos inspection, different things but I kept in touch, like you asked me, magistrate, with Miss Jocelyn to get everything done, and I've done it, and I'm here today to ask you to consider the fee for me, because I'm not able to pay the whole thing.
How much are you asking for? This was $69,750. And confirm me if I'm incorrect, Officer Ramirez. And the town has agreed to an 85% reduction, which brings it down to $10,463. Is that correct, officer?
I'm paying for the place that I still have a contract in. I'm not able to. Judge, I can tell you I can pay. If it was something $2,000, I can try my best to pay it. But at $10,000, it's very hard for me. If they can abate it less than 85%, please help me out, because I am not
Ms. Claudine, do you know how much you paid the contractor to demo the pantry room?
The contract up close to $5,000 was the contractor alone. The architect was another $1,200. It came out to be about $10,000 paying for the new plan, the new paperwork to be put in, the asbestos, the wall,
asbestos.
yes, all of these things, and the every move they make, they ask for $2,500 more, and this
And you also no
Paying.
longer, you've had to shut down your business.
I had to shut down everything.
Are you losing money from shutting down your
The
business?
people that support me, because we do a nonprofit thing that support the group, it's a prayer group that I have, Judge, to have people come and pray, and it's a small meeting group. It's a room because my living room cannot have the people there. So I found this place and I thought I was able, but nobody can support it because they said they're not there. It's coming out of pocket for me. I don't know. It's just it's a lot for me, Judge. I know I'm sorry for the step that I took, that I should have waited for the permit, but and I have a contract with the landlord that I'm still paying for, and I'm sorry.
No.
I'm trying today not to let it run.
No, I understand. Is there any more testimony on either side?
Not at this time.
Okay. I see a gentleman with his hand raised. Are you
I'm
with
the realtor of the owner of the shopping center.
where this business is located? Okay.
If my testimony helps in somehow, they're amazing tenants. They pay 2 weeks.
If you can please speak into the mic, state your name for the record and the address.
My name is Kadir Puentes, realtor of VNA Miami LLC, 4400 West Hollandale Beach Boulevard. They're very great tenants, great people. They pay 2 weeks in advance. Never had an issue with them. We will to remain there, but this is something that I will need to speak with you maybe after this. But if somehow you can help them with the reduce of the fines, that will be great. Thank you.
Thank you for your testimony. Based on the testimony and the evidence presented, I'm going to reduce your mitigated fine to $3,000.
Amen. Hallelujah.
And that's based on the testimony, you working with the town to come into compliance, realizing your nonprofit, the testimony of, I'm sorry, I forget the gentleman's name. And Officer Ramirez, remind me, was the $100 fine, admin fee paid?
Yes.
Okay. You will have to pay the $3,000 in 30 days, or the fines resume to what they were.
Oh, God bless. I will work day and night. Thank you, Judge. Miss Ramirez, thank you. I cannot say more. Overtime, here I come.
Yes, and stay in compliance.
Yes, I'm trying.
She hasn't paid the admin, right? Yeah. Miss Claudine. Okay. Thank you. Next case when you're ready, Officer Ramirez.
Next case is on section 9.5 on the agenda. Case 7110. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7110, property owner VNA Miami LLC, site address 4400 West Hollandale Beach Boulevard, unit number 5. Notice of hearing to abate fine was requested via email on April 18, 23rd. The total accrued fines is $61,000. It is town's motion to abate this fine by 85%, and the amount is $9,150.
Good morning again. If you could restate your name for the record for this case number.
Good morning. My name is Kadir Puentes. I am the realtor of the owner, VNA Miami LLC.
Okay.
This property was managed previously by another company and realtor, and I inherited 8 to 9 issues, and I've been cooperating with Officer Joseline Ramirez. We're down to actually 3 more, and this will be the last 2. We're finalizing number 4, which they're also in compliance right now. We would like to make a request to further down, abate this maybe to 90 or 95% if possible. All the tenants, we've been having issues, but everything we're being cooperating and resolving everything, fairly quickly. And since it's the landlord that needs to pay this instead of the tenant, and we've been responsible for now cooperating tenants, and like I said, fairly quickly we've been resolving this. So.
Officer Ramirez, can you confirm for me when this came into compliance?
March 16, 2023.
And the date of the notice of violation was issued when?
May 23rd, 2022.
I've been working on the shopping center since November, so
Of 2022?
2022, late, end of November 2022.
This is when your company took over?
Yeah. Well, I don't manage the place per se because I'm not a management company, but I'm his realtor, and he lives in Colorado.
Okay.
So I've been trying to help him, get everything in order.
This is also, this was a repeat violation. Unfortunately, in this plaza, we've had also people come in, they start their business without a BTR, they start changing the place without permits. So it is a repeat offense. As you can see, our previous case was the initial violation. This is a repeat. And I also, the amount is actually $9,250 because they have not paid the administration fee.
Okay.
But I know that they did have trouble with their tenant, and I believe that you got a second tenant. Am I right?
So the main issue with the plaza is that almost every single tenant did something they were not supposed to. But this was previous till I got there, so the leases that they have were a mess. Management was a mess. The whole thing was a mess. But I believe she can attest that since November,
They had a property manager that wasn't present. He was in another country, so he was not keeping an eye on the plaza. So Mr. Kadir did inherit a lot of problems when he came in to manage, but he's been more present. And I know that he's been in constant communication trying to fix and close all these cases that was inherited to him.
So from 8 cases, we're down to 1, pretty much.
Is that confirmable?
I'm sorry?
He said of 8 cases, they're down to 1.
So we have.
I can't confirm.
Okay.
So there are three cases open. Number 4, which is Bernie's Kitchen. Number 5, which is 554-7110, and number 3 will be the lady from number 6, Annoyance. So 7110 and 5549, we're closed because we're rolling. And then I have the money order for the application of number 4. That will be the last case. And I'm gonna drop the money.
As far as BTR and tenant build-outs cases, yes, there's just there's down to 1.
And last week she gave me a notice for some
For
we need to
maintenance.
get done 7 things. I already fixed 4 of those 7, and the last one will be just the publicity on the window, which I was advised to wait to see what's going to happen with that. And the last one will be the wall that I'm getting quotes for companies for them to do the job. So, we'll be moving fairly quick.
So I'll reduce. Do you have more to add?
Oh, yeah, I can wait.
I'll reduce the mitigated amount by $1,000, bringing it to $81.50. You will be assessed $100. But what I want you to take back to the owner of the plaza, because this is a repeat violation, is that it's great to be an owner, but you have to be present, and they are responsible for all of the units. And it's incumbent upon them when they engage or contract a tenant to explain to them that they have got to come down to the city and apply for any and all permits if they have any thought or desire of making interior changes. Because the next time that the plaza is before, it won't be so generous. And Officer Ramirez and the town have been quite tolerant of the repeat violations. So please, go back to your boss and tell him, look, speak to his tenants, and that should be really something that should be ground floor to avoid even being here to begin with.
Yeah. No, the tenants, they don't like me so much because I'm very strict. But the last thing that I wanted to mention is this is about the case for the lady, Annoyance.
The prior case?
Yeah. They're going to pay the fine, but the issue that I have with that tenant is that I was advised that they're not going to get issued because of their usage a BTR, meaning they cannot stay there. So how can I make sure of their application to see if we should terminate their lease or not?
I sent you an email with the planner's information, contact.
Okay.
She will have to speak to him. Maybe he can guide you as to what type of business she can move forward with. But she still has to go through the zoning process to get that approved. If the planner doesn't approve it, then she can't continue.
Okay, perfect. Thank you.
So based on the testimony and the evidence presented, I find there's substantial and competent evidence to support the city's position of the abatement, which I am reducing by $1,000, so it's $8,150 with $100 administrative fine. The $8,150 and the $100 must be paid within 30 days, or the amount will resume to the original fine amount.
Okay.
Thank you. Good luck to you.
Thank you. Thank you.
Next case.
Next case is section 8.3 on the agenda, case 6051. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 6051, property owner Infinity Azure LLC. Site address 3252 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail March 24, 23rd, posted to the property and town hall April 7, 23rd. An abatement request was sent via email on April 18, 23rd. So instead of imposing a lien, we're going to abate the fine today.
And this is case 6051 Infinity Azure LLC?
Yes.
Okay. So they're in compliance?
Yes.
Okay.
It is the town's motion to abate the fine of $18,850 and reduce it by 85%. The total amount, including the administration fee, is $2,913.
Good morning. Please state your name for the record and your position.
Good morning. I'm Juani Merced, and I represent Infinity Azure.
Okay. So you've heard the officer's testimony with regards to the abatement amount of $2,913.
Yes.
Very generous considering what this violation was for.
Yes.
Okay.
I do appreciate it, but because we've been I know we have other cases and things like that. We have been spending a lot of money in all this, and also getting contractors, and they brought me on board to be on site. So I'm requesting maybe to get even reduce or waive the fee. So that's what I'm here for.
Anything else on either side?
I would just like to add that it is true. Miss Juani, she inherited a lot of problems in the units. They've had to replace multiple water heaters, get permits for AC units. They've been repairing roofs because of major leaks. And they also redid the parking lot, and there's much more maintenance and repairs that they continuously have to do because the complex itself, it's very old, and so they've are having a hard time upkeeping with the expense and the maintenance of the place. So I just like to add that, but that's all for me.
And I would like to say that moving forward, we've been in compliance, and I've been in constant communication with Jocelyn when we act very quickly. So moving forward, I don't think we'll have any more, issues or violations.
I strongly encourage that relationship to continue. Unless there's anything else on either side, I'll pronounce the ruling. Okay. Based on the testimony and the evidence presented, I find there is substantial and competent evidence to support the city's position for abatement. The property or the violation is in compliance. I am reducing the abated amount recommended by the city by $400. So that will be an amount of $2,413. There are $100 administrative fine assessed, which brings the total to $2,513. That must be paid within 30 days or the original fine amount will resume.
Okay. Thank you.
You're welcome. Good luck to you. Next case when you're ready.
Next case is on section 7.1 on the agenda, case 5812. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5812. Property owner Barry Cunningham, site address 7 Sunny Lane, Pembroke Park, Florida. A notice violation was handed on May 5th, 2021, sent by regular mail, May 5th, 2021. A notice formal hearing with a copy of the notice violation was sent by certified mail on March 31st, 23rd, posted to the property and town hall April 7, 23rd. The violations were for item number 1, new window installed without a permit. Item number 2, new doors installed without a permit. Item number 3, camera system installed wired without a permit. Item number 4, roof was altered without a permit. Item number 5, new lights added without a permit. Item number 6, verify the number of occupants occupying the home, as only one family can occupy the home. And item number 7, verify with building department if the stairs and vinyl siding was permitted. I also like to add that this case was former officers Teresa Malcolm. So I went ahead and did a reinspection of this case as of March 29, 23rd. And I gather evidence that there's permits for the vinyl siding and there's permits for the lights that were installed. There's only one family occupying in the home. And I was told that the cameras have been removed. So that will comply with the violation. And so the only items that are remaining is the permits for the windows, the permits for the doors, and the alteration of the roof. So those are the 3 remaining items. So it is my recommendation to give them 60 days to fix those items, and if not, a $100 per diem with a $100 admin fee.
Good morning.
Good morning.
Can you state your name for the record and your position on the case?
My name is Barry Cunningham. I'm the owner of the trailer.
Okay.
And they gave me 60 days more, and I hope to have it all done. I hired a Stephanie permitting thing, and she's got an engineer supposedly she hired yesterday to take care of the drawings. So I'm hoping to have this done within 30 days, but I do appreciate the 60 days.
Okay, great. Based on the testimony and the evidence presented, I find that there is substantial and competent evidence to support the city's position. You are hereby ordered to come into compliance within 60 days or face a $100 per day daily fine. You are also assessed a $100 administrative fee for this case.
Okay.
If you could have a seat, and we'll provide you with the order.
Thank you very much. I appreciate it.
You're welcome. Good luck to you. Next case when you're ready.
Next case is on section 10.2 on the agenda, case 6185. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6185, property owner Nation Dom Inc., site address 5100 Southwest 41st Street, Pembroke Park, Florida. Request for extension of time was sent via email April 14, 23rd. The violations are for installation of new water heater without a permit, installation of new AC unit without a permit, damaged ceiling, exterior maintenance of balcony, exterior roof requires maintenance, to assess damage causing leak, repair roof to prevent leaks according to the Florida Building Code, installed new kitchen cabinets without a permit, exposed light bulbs in kitchen area. There are 7 items on this violation. And currently, I have not done an inspection of the home of any of the items that were resolved, but the owner has been in communication with me and mentioned that they have made those repairs, the repairs that don't require permits, like either patching the ceiling for the leaks and things like that, and covering the light bulbs. As far as permits, the owners is having a difficult time with the contractors. So I don't see any permits in the system. I know there's a lot of items, so I am gonna suggest for an extension. This is the second time this has come around. So I'm gonna suggest 60 days to complete everything, but it would be the final extension.
Good morning. Can you please state your name?
Good morning. Yes, I'm Nikita.
Are you the owner, Nikita?
Yes.
Okay. And you've heard the officer's testimony. What's your position on this?
Yes, I'm okay with the 60-day extension. Like she said, everything that doesn't require a permit is done. We can schedule an inspection for that.
Yeah.
Regarding the permits, mechanical and plumbing, they should be submitted to you guys any day. The only one that is still pending is for the kitchen cabinets. But I'm okay with the 60-day extension.
And Officer Ramirez, the per diem?
The per diem stays the same, is $250.
Okay, just wanted to confirm. Okay, based on the testimony and the evidence presented, I find that there's substantial and competent evidence to support the city's position for an extension of time. You are so ordered to come into compliance within 60 days. The $250 per diem daily fine still applies. You are also assessed a $100 administrative fee.
Okay.
Okay, good luck to you.
Thank you.
Next case when ready.
Next case is on section 10.5 on the agenda. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7858, property owner Holiday Hallandale MHC LLC, site address 3140 West Honda Beach Boulevard, Pembroke Park, Florida. A notice of hearing to extend time was requested. It was sent by certified mail in March. Let me get you that date. March 24th, 23rd, and posted to Property and Town Hall April 7, 23rd. The violation was for construction work being done on the pool area without permits. The property manager is working diligently to get the permit, the contractors to get the permit and to start the work. This is the first extension request. So I'm going to suggest that they have 90 days. If not, a $250 per diem and a $100 admin fee.
Good morning. If you could please state your name for the record and your position on this matter.
Good morning. My name is Marlene Hernandez. I'm the general manager at Holiday Mobile Estates. For the record, we just got the permit for the pool on Monday and work started today. So hopefully within the 90 days, it will be completed.
Okay, great news for you. So, yes. Based on the testimony and the evidence presented, I do find that there is substantial and competent evidence to support the city's position for an extension of time. You are hereby ordered to come into compliance within 90 days or face a daily per diem fine of $250 per day. You are assessed $100 administrative fine for today.
Okay, thank you.
Good luck to you.
Thank you.
Next case.
Next case is on section 8.4 of the agenda, case 7193. Chief Code Officer Joseline Ramirez for the Town of Pembroke Park, case 7193, property owner Raycom LLC, site address 5510 Southwest 32nd Street, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail March 31, 23rd, posted to the property April 7, 23rd.
Good morning, Your Honor.
It is, I'm sorry. Almost done. It is the town's motion to confirm the fine of $30,350, which has accrued for 121 days.
Officer, can you give me that accrued amount? This is in a,
Yeah.
29,000?
$30,350.
$30,350.
$50.
Thank you. Good morning. Please state your name for the record and your position on this matter.
Yes, I'm Soanis Cuevas, and I'm the Assistant Property Manager for Raycon. Just to give some background, basically the property, we had a tenant who gave us a lot of burden financially, not taking care of the property, parking on the grass. I mean, this is a lot of escalation of notices, non-compliant that led to eviction. Finally, we were able to terminate the tenant and vacate it on the 31st of last month. And we had submitted applications for the permits because, you know, we hold up the lawn because we have to do the parking lot, and that requires, you know, a lot of labor work. And also, you know, being of the cost of several other fines and having the tenant that was bringing garbage and parties, and, you know, it was a lot of commotion with the tenant being there, not cooperating with us, that led to the grass being deteriorated. And then putting the fence that kind of, he made his own division between the yard that led to another violation. So the fact is that we had complied as far as clearing the fence, that division. The neighbor put up a fence, so therefore it's being complied by a third party. But we are pending with now with the permits to start with the parking lot, and immediately that's over, we have an approved quote with a vendor to do the lawn. So it's kind of gradually being in progress. We really, you know, apologize for the delay, but it was because we had a really bad tenant that held us in neglecting the property, basically. And they request a lot of mediation with the city, and it was like an unfinished case that finally led to be vacated in March. So we definitely want the property in compliance. We're doing the best we can, and it's just a matter of timing to bring everything to close. So we just want a little more of, you know, an extension of time to let this unfold.
Okay. This has come forward for an imposition of the lien at this time, but what we can do is postpone this confirmation of fine, and you will have to complete an extension form request and submit it to me, and then we can see where you're at that point. You know what? Because right now, when I did the inspection of the property, everything is still the same. But as you explained, you were having an eviction, so I didn't know that information until you mentioned it right now.
I understand. I just received text messages because I have a maintenance person who went by and confirmed, because as of the 31st is when the tenant vacated, and then we have a crew coming in, cleaning out the property, and I have pictures that I can provide to you by email or text, but they're available. The fence, like I said, was done by a third party, and we have cleared the division fence in between. But we do agree that we are pending for the permits, which has been submitted to the city. I have here the plans and per application record that it has been submitted.
So within the 8 months, what has been done? Like, when did you submit that permit application?
The plans were started in February 7th. I can get back with you as far as with the application, because that's not my doing.
Okay.
But it has been submitted. I have a application here.
Okay, because the violations is the entire parking area is in disrepair. The parking area has no lines and stripes separating parking spots. There are bare spots on the lawn of this property. There's fence that has been installed without a permit. So, and there is a damaged fence currently on the property that possibly has to be replaced. My question, this is the violation that was sent on June 28, 22. And then there was a hearing on October 3rd, 2022. So I want to know in that time frame, because I understand that there was an eviction. I understand there was a problematic tenant, but that doesn't impede for you to repair the parking lot. That doesn't impede to repair a fence. A tenant cannot cause issues to repair those things. And this has nothing to do with the unit itself. If I'm explaining myself correctly to you, the tenant wouldn't stop any of the maintenance to continue in this place.
Yes. Okay. Line 1, the fence that actually divides the neighbor. The neighbor, I back in 2022, I was not handling that case. I can respond for this year, but I actually spoke to the neighbor, and they're the one that replaced the fence that was damaged.
Right.
We don't have,
which they've been cited as well.
Okay, well, but they were the one who replaced it.
Mm-hmm.
So being that they done it, we left
Okay,
it at
so let's leave the fence aside. Why,
So
until now, we're getting a permit for the parking lot. What, until now, has there not been anything done for the lawn because putting sod doesn't require a permit?
Okay. What happened is that in the past, we have put sod, have instructed the tenant not to park there, to let the grass, revive and grow. But they continually parked on the grass. And that's why we decided to terminate the tenant, because he only lived there for less than a year, exactly. So we were giving them notice. We kept repeatedly that we put seeds. But it was an investment that, being that the parking lot had to be done, the owner was considering all options to alleviate that cost. The tenant did not comply and just made the grass even worse. And that's why we had to actually terminate the tenant. Now, in terms of the parking lot, part of the reasons that the tenant says that they're parking on the grass is because there's only 2 parking spaces and not enough for the 2 families that live there. So the owner decided to request permits to amplify the parking space and not make it a recurring event. So this is a plan to convert the parking instead of 2, but into 4. That's a bigger project of what is actually, we want to not come back 2 years later with the same case with a new tenant. So that's why it was kind of...
and how much time would you be requesting?
Well, we finally got the appropriate vendor and contractor to do the work at affordable cost. The application has been submitted, so now it's with the county or the state, the city, when the permit's unfolded, to just start the work. And the property is vacant, so we should not expect any hold off on that.
So how much time you're requesting for everything to be completed?
If we could, I mean, for the parking, I mean, 60 days should be, I mean, I really don't know the timeline with the city, how are they with this? But I mean, 60 days, 120 days should be maximum from permits to execution.
Okay. But as I mentioned, the sod doesn't require permits.
No, the sod was only held off because if they're gonna be
But
working.
now you can do it, right?
Can do it, yes.
Okay. Attorney, town attorney, interim town attorney. Can we decide if we can do an extension now, or do we have to bring it back to the next hearing?
Since this hearing was properly noticed and this is the respondent, with the approval of the magistrate, you can do the extension now. Again, it's just a matter of what the order is going to be, so you don't have to set another hearing for that.
Okay. Madam Magistrate, with your approval, instead of just postponing this confirmation of fine, I would suggest that we give an extension of 60 days. If not, then we will hear this case in May. But with your approval, if you approve the extension, then we go forward with the extension. If not, we'll hear it on May.
If I may ask one question, Ms. McKinney, for a clarification. By extension, are we just continuing this hearing and the fines continue to run, or are you modifying the previous order? Or is that
Modifying the previous order.
Thank you.
I thank you for considering.
The previous order, for the record, just so that we're all on the same page, that was entered October 19th of 2022.
When you mention, interim attorney, when you mention about modifying the order, did you mean the order on the record, or you meant the order that was placed in the past?
Specifically, I'm referring to the compliance date. If you're, by extension, are you extending the compliance date, which would then in turn, of course, extend the, or eliminate any of the prior fines? Or as far as extension, are you just essentially just asking for a continuance of this hearing, which then it's the same thing as far as extension versus just the mere continuance of this hearing and resetting it for a future date?
Okay, I understand the question now. Yes, we will be modifying the final order, so it will be an amended final order.
And that was 60 days. And the record reflects the final order previously issued had a $250 per diem daily fine. That's still
yes.
The city's, okay. What was your last name again?
Cuevas.
Cuevas?
Cuevas.
Okay, and you're the representative of the owner.
Yes.
The city has been very gracious today in not objecting to your request because it's been a very long time. The violation, and I understand sometimes there are tenants that impede the owner effectuating compliance matters, but this was a very generous agreement with the city. So based on the agreement of the parties, along with the testimony and evidence presented, I find there is substantial and competent evidence to support the request for an amended final order granting 60 days to come into compliance or face a $250 fine, daily fine. There will be $100 administrative fees assessed for this hearing. You have any questions?
No, we thank you for the consideration and generosity. Thank you.
Yes, thank the town.
Thank you.
So we can strike this.
Yeah, yes, so we will send, since we don't have a drafted order at this time, we will send it certified mail. Or if you would like to request it via email, you can send me an email.
Okay.
And you can send me your contact too. Everything, whatever you like to enter in the case, okay?
The first one?
No problem.
Thank you.
The October 2019.
She has the folder.
Oh, okay.
Joseline.
Maybe photocopy that in a white out and just put amended. Make a copy of that and put amended.
For me, it's not
You're gonna mail it to
I
her?
can do it.
Yeah, we'll do an order after.
Okay.
And then you can sign it. But we're gonna send it certified mail
Okay.
All right.
since this was not planned. I guess.
It'll be amended.
Amended final
Yeah.
order.
Mhm.
Yeah. I corrected. Sorry.
Oh, 3100. Next case, officer, when you're ready. Thank you.
Next case on section 9.1 on the agenda, case 4798.
Nine 9.1.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 4798. Property owner Magali Campos dash Licea. Site address 111 Lone Pine Lane, Pembroke Park, Florida. A notice to abate fine was requested on April 10, 23rd. It is the town's motion to abate this fine to $148. The fine is $1,000. It accrued to $1,000, and we're abating it to $148 with 50 cents. That is the administration fees and the recording lien fees, the $148.50. The reason why we're reducing the $1,000 per diem fine is because the property owner was in an amnesty program and they've complied with all the violations.
Please state your name for the record and your position.
My name is Azul Suarez. I do everything.
Well, congratulations. It looks like you successfully completed the amnesty program. So based on the testimony and the evidence presented, I find that there is substantial and competent evidence to support the city's abatement recommendation upon your completion of the amnesty program. The record reflects that you've paid the administrative fine of $148. So you will get an order that says $0 paid in 30 days because you're all paid up.
Thank you.
Congratulations. Good luck to you.
All right, thank you. Nasli is going to give you the abatement order, and we're also going to send you a copy of the affidavit of compliance.
Okay.
Okay.
Thank you.
Madam Mayor, if we may, can we take a 5-10 minute recess?
Yes.
I guess we'll go in the order of the agenda.
That works.
I'm trying this computer thing and I don't think it's working for me. So the next case will be on section 7.2 on the agenda. Case 7722. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 7722. Pembroke Park, property owner Pembroke Park Warehouse Holdings, site address 3140 Pembroke Road, Unit 612, Pembroke Park, Florida. A notice violation was sent by regular mail on October 2022. Notice of formal hearing with a copy of the notice violation was sent by certified mail April 7, 23rd, and posted to the property and town hall April 7, 23rd. The violation is for business owner is conducting business without proper business tax receipt. As of March 28, 23rd, I issued an affidavit of noncompliance for not having a bid TER, and on April 7, when I did the posting, the business owner still did not have a business tax receipt and did not have it on display as well. It's my recommendation, since this plaza has repeat violations, to give them 15 days. If not, $500 per diem and $100 admin fee.
Is anyone here on case number 7722? Seeing no one come forward, based on the testimony and the evidence presented, I find there is substantial and competent evidence to support the city's position. The respondent is hereby ordered to come into compliance in 15 days or face a $500 per diem daily fine. This is a repeat violation. Administrative costs in the amount of $100 are also assessed for today's hearing.
Okay. The next case on section 7.3 on the agenda. Case 7734. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 7734, property owner Pembroke Crown LLC, site address 2565 South Park Lane, Pembroke Park, Florida. A notice violation was sent by regular mail October 21, 22. A notice form of hearing with a copy of the notice violation by mail on March 29, 23rd, posted to the property and town hall April 7, 23rd. This is a repeat violation referencing case 4934 and 4935. The violations are for operating without a business tax receipt and certificate of use. As of March 29, 23rd, I issued an affidavit of noncompliance. There are several inspections that were failed, so therefore the business owner still does not have a BTR. Since this is a repeat violation, I can suggest to give them 15 days and a per diem of $500 with a $100 admin fee.
Is anyone here on case number 7734? Seeing no one come forward, based on the testimony and the evidence presented, I find there is substantial and competent evidence to support the city's position. The respondent is ordered to comply or come into compliance within 15 days or face a $500 per diem daily fine. This is a repeat violation. Administrative cost in the amount of $100 will be assessed for today's hearing. Next case.
Next case is on section 8.1 of the agenda, case 4862. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 4862, property owner Frami Nunes Batista, site address 3140 West Hallandale Beach Boulevard, lot 524, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail March 24, 23rd, posted to the property and town hall April 7, 23rd. Confirm the fine of $32,400. It accrued for 646 days.
Is anyone here on case number 4862? Seeing no one come forward, based on the testimony and the evidence presented, I find there is substantial and competent evidence to support the city's position to confirm the fine. The total fine amount to date is $32,400. There is a continuing $50 per day daily fine, which will continue to accrue until compliance is achieved, and $100 administrative cost will be assessed for today's hearing.
I also would like to add on the record that the property owner, Frami, did contact me, and she did mention that she could not be in today's hearing.
Okay. Thank you.
Next case is on section 8.2 of the agenda, case 5808. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5808, property owner Claudine Lazard and Serge Lazard. Site address 102 South Key Drive, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail March 31st, 23rd, posted to the property and town hall April 7, 23rd. It is the town's motion to confirm the fine of $26,150 that accrued for 521 days.
Is anyone here on case number 5808? Seeing no one come forward, based on the testimony and the evidence presented, I find there is substantial and competent evidence to support the city's position to confirm the fine, $26,150. There is a continuing daily fine in the amount of $50, which will continue to accrue until compliance is achieved. There is a mandatory $100 administrative cost assessed for today's hearing. Next case.
Next case is on section 9.3 of the agenda, case 5680. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5680, property owner La Estancia of Broward County Homeowners Association, Inc., site address Southwest 41st Street, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail March 17, 23rd, posted to the property and town hall April 7, 23rd. Just one moment, just want to make sure that the admin fee was paid for this one.
Yeah, my notes reflect they were when I looked at the agenda. The invoice reflects that it was.
Yes, it was. Okay, so it is the town's motion to abate the fine of $16,650 and reduce it by 90%. The total would be $1,665.
Is anyone here on case number 5680? Seeing no one come forward, based on the testimony and evidence presented, next case.
Next case is section 9.4 of the agenda, case 5699. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 5699, property owner Rollins Continental Inc., site address 1820 Southwest 30th Avenue, Pembroke Park, Florida. Notice it's supposed to be reduced by 85%. Says here 90%. Hold on a second. Let me see if I can get you the number. Is this the agreed order?
Yes.
Okay, they're generating agreed order.
What happened?
No, it says 90%. The reduction had to be 85%. If interim attorney, if we already agreed, we should just keep it the same, right? Not go back on the.
Correct.
All right, let me just make sure that this was the same amount that we sent. Okay, so there's a town's motion to reduce the fine of $23,350 and abate it to $2,384. That includes the recording lien fee. And the admin fee was already paid.
Anyone here on case number 5699? Seeing no one come forward, based on the testimony and the evidence presented in the agreement of the parties, I find there is substantial and competent evidence to support the city's or the agreed parties' order of abatement. The respondent is hereby ordered to pay $2,384 within 30 days.
Okay, let's go back to the agenda.
Officer Ramirez?
Yep.
My notes reflect that we have an add-on for abatement of case number 5070. Did we dispose of that?
I would like to rescind that because I just messaged during our break. I messaged the property manager, and there was some miscommunication. He was trying to call us yesterday, but we were not in the office. So I told him I'm going to put him for May.
Okay, thank you.
Thank you for clarifying that. Okay. The following cases to be heard is case 5672, which is on section 10.1. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 5672, property owner Prologis Exchange, Pembroke Park Road and 30th Avenue, LLC. Site address 3876-3880, Pembroke Park, Florida. A notice of hearing to extend time was requested via email on April 14, 23rd. There are 4 violations on this property. They have completed 3 of them, and the only remaining one is the permits for the electrical security camera system that was installed without permits. So they are working on it. They need more time to complete this permit. So it's my recommendation to give them 60 days. And the per diem stays the same, $250, and the $100 admin fee.
Anyone here on case number 5672? Seeing no one come forward, based on the testimony and the evidence presented, I find there is substantial and competent evidence to extend the time for compliance. The respondent shall come into compliance within 60 days or face a $250 per day daily fine. There is also a $100 administrative fee assessed for today's hearing. Next case.
Next case, section 10.3 on the agenda, case 6541. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6541, property owner BH2550 LLC, site address 2550 Southwest 30th Avenue, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail March 31st, 23rd, posted to property and town hall April 7, 23rd. There are 3 violations for case 6541. They have completed 2 out of the 3 violations. The remaining violation is the removal of an abandoned sign. It's a large pole sign. So they need more time to complete the permit and inspections and to actually remove that big sign. So it's my recommendation to give them 60 days, and per diem fine stays the same, $250, and the $100 admin fee.
Anyone here on case number 6541? Seeing no one come forward, based on the testimony and the evidence presented, I find there is substantial and competent evidence to support the city's position to extend the time. The respondent shall have 60 days to come into compliance or face a $250 per diem daily fine. A $100 fee is assessed for today's hearing. Next case.
Next case on section 10.4 of the agenda, case 7706. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7706, property owner Eric Diaz, site address 76 West Lake Drive, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail March 29, 23rd, posted to the property and town hall April 7, 23rd. The owner wanted to request time to complete her permit for the AC unit. There are 2 violations. That was the only remaining one. They did complete the permit, but for record purpose, I would like to extend this time for 10 days. And all the property owner has to do is pay the administration fees.
Case number 7706. Is anyone here on that case? Seeing no one come forward, based on the testimony and the evidence presented, I find there is substantial and competent evidence to support the city's position to extend the time. Respondent shall come into compliance within 10 days. Respondent is also assessed a $100 administrative fee for the cost of today's hearing. And Officer Ramirez, just for clarification, there is no daily accruing fine on this matter. if they do not come into compliance within the 10-day period?
Correct.
Next case.
Next case is on section 11.1 of the agenda, case 6051. Chief Code Officer Joseline Ramirez for the town of Pembroke Park, case 60, I said 51, it's case 6057. Property owner Serge Lazard and Claudine Lazard. Site address 104 South Key Drive, Pembroke Park, Florida. A notice of violation was sent to the owner, July 26, 2021, and it was for vinyl siding replaced on mobile home without a permit. I would like to vacate the final order that was issued on October 19, 22. After my discussion with the interim building official, vinyl siding replacement doesn't require a permit. If they put like material, it doesn't require a permit. And as far as my inspection on April 7th, the property owner did replace it with like material for a mobile home, and therefore there is no violation. And the town would like to move forward and vacate the final order that was issued on October 19, 22.
Case number 6057. Is anyone here on that case? Seeing no one come forward. Case number 6057 is here on the city's motion to vacate. Based on the testimony and evidence presented, I find there is substantial and competent evidence to support the city's position to vacate the final order entered on October 19th, 2022. The town's motion is hereby granted.
And that will conclude all my cases.
Almost on the dot.
Would you like to adjourn, or is there any discussion?
Any discussion by anyone? Discussions from anyone? We stand adjourned.